Good evening, all. My name is Vic Amar, and on behalf of the College of Law at the University of Illinois Urbana-Champaign, a splendid institution where I am honored to serve as dean, I am pleased to welcome you here to the beautiful Follinger Auditorium for the second lecture in a series hosted by the College of Law entitled The New Lincoln Lectures: What Lincoln Means to the 21st Century. In this series, we are privileged to be hearing from a remarkably accomplished and ideologically diverse set of national thought leaders on Lincoln's legacy and his continuing relevance 150 years after his passing. As I said when I introduced our inaugural lecturer, Bob Woodward, in January, the law school has chosen to focus these lectures on Abraham Lincoln in part because Lincoln is undeniably among the greatest lawyers in America's history. The fact that he assumed many other important roles, president, legislator, military strategist, newspaper owner, etc., merely adds to his legacy and his legend. As we know, many of the themes of Lincoln's life and his life's work, the treatment of race and non-citizenship, the relationship between the national government and the states, the scope of executive power, the interplay between the president and the Supreme Court, the conduct of a presidential election campaign in a time of bitter partisanship, among others, dominate discourse today nearly as much as in Lincoln's era. So this remains the right time for all Americans to reflect on Lincoln's meaning to each of us and all of us. This is especially true for those of us here at Illinois. In a real sense, the University of Illinois, located between Springfield and Chicago, is Mr. Lincoln's university. As we in Champaign-Urbana prepare to celebrate our own sesquicentennial next year, we must never forget that we were among the first of the land-grant universities, created in 1867 by the act signed into law by President Lincoln 5 years earlier, and the only one in that original group founded in Lincoln's home state. And who better to help us at this time and in this place think about what we can learn from Lincoln as a country and as individuals than George Will, one of the finest minds this region has ever produced. Mr. Will was born and raised in Champaign, where his father was on the faculty here at the U of I. He attended the Child Development Laboratory program in town and went on to graduate from the University Laboratory High School. He worked for the now defunct Urbana Courier newspaper, where I understand he had a friendly rivalry with Roger Ebert, who worked summers at the News-Gazette in Champaign. From Champaign, Mr. Will went on to Trinity College and Oxford University, and then on to Princeton, where he earned his PhD. And the rest, as they say, is history. He is undeniably one of America's most prolific and influential thinkers and writers. His 12 books include One Man's America, The Pleasures and Provocations of Our Singular Nation, Statecraft as Soulcraft, and Men at Work, The Craft of Baseball. His regular column has been syndicated by the Washington Post since 1974 and today appears in about 500 newspapers. For 32 years, he was a panelist on ABC television's This Week. He has been awarded the Pulitzer Prize for commentary, the Solarian Award for editorial writing, and the Champion of Liberty Award from the Goldwater Institute, among many, many others. In 1986, the Wall Street Journal called him, quote, perhaps the most powerful journalist in America, and the Chicago Tribune has dubbed him, quote, America's leading poet of baseball. For me, three things stand out above and beyond his innumerable intellectual contributions and accolades. First is his television fame. I refer here not to Fox News or his incredible run on the ABC Sunday talk show This Week, although I must say I learned a lot about how to think like a lawyer from watching him on that show on Sundays in the 1980s and 90s, even though he, like Abraham Lincoln, never attended law school. But more important than all that, Mr. Will is such a household name that, like Mickey Mantle and Joe DiMaggio, he was the subject of a fixation by the Kramer character in an episode of my favorite TV show, Seinfeld. Second is Mr. Will's loyalty and dedication, as evidenced by the fact that he is a diehard Cubs fan. I have tremendous respect and affection for Cubs fans, and I wish him and the Cubbies well, but I think it only fair to tell him that he will have to wait until 2017, since my beloved San Francisco Giants win the World Series in congressional election years going back to 2010. Finally, moving from the diamonds to the gridiron, he is reported to have said, quote, "It speaks badly for a university to have a good football team." On this point, I must disagree. But I should add that if Mr. Will's observation is true, I very much hope that the converse is also true. For if so, during the past few years, we have been an even greater university than I ever imagined. It is my great pleasure to welcome Mr. Will to the podium. Before he begins his remarks, let me say that although today is Super Tuesday, a big day in the presidential election campaign, kindly Mr. Will has framed his remarks around President Lincoln and the personal meaning President Lincoln has for him, so he's not going to do a political roundup in his remarks, but after the formal program there will be a Q&A, and he will take wide-ranging, broad questions at that time. So let's welcome him out onto the stage.
Thank you. Thank you very much. Thank you very much, Dean, for that generous introduction that proves that not all forms of inflation are painful. With regard to the Cubs, it is the case that I only write about politics to support my baseball habit. But you talked about waiting. We've been waiting 107 years since 1908, the last time the Cubs won the World Series, which was 2 years before Mark Twain died. So the 107-year rebuilding effort is over. Now to the 16th rather than the 45th president. Here in central Illinois, where men are men and I am from, people develop, or at least in the 1940s and 1950s they did develop, what I consider an admirable Midwestern reticence about themselves. Although I left Champaign-Urbana to go to college in 1958, 4 months after my 17th birthday, I have never, not for a moment, ever stopped thinking of myself as a Midwesterner. I am, in the words that are the title of Hamlin Gardland's once famous book published 99 years ago, a son of the middle border. As such, I still adhere to what I consider a Midwestern reserve in talking about myself. I retain a Midwestern inclination not to share my feelings with others and to thank others for not sharing their feelings with me. Which is why there hangs on my office door in my Washington office in the Georgetown section a framed New Yorker cartoon that is my personal proclamation against today's confessional culture. The cartoon depicts a man dressed in a suit and tie and reclining rather stiffly on a psychiatrist's couch with the psychiatrist sitting behind him, pen and notebook in hand. In the cartoon's caption, the man on the couch says, "Look, call it denial if you like, but I think what goes on in my personal life is none of my own damn business." However, Dean Amar's agreeable summons to speak at this occasion involved an invitation to be somewhat autobiographical, to lift, as it were, a curtain and say something about a formative influence on my thinking and my life's work. One influence on my life's work, I should say, was work, some of it related to this university. One of my summer jobs was as a human scarecrow to chase birds away from an experimental garden plot run here on the campus. Back in the day, I was a pin setter, this was before automation, in a bowling alley in the Illini Union. During another summer, I worked for the local building supply company that supplied the concrete for the roof of the assembly hall. However, the largest influence on my life's work was, and still is, Abraham Lincoln. So I have come here to explain why one of the most important events in my life, one that continues to shape my thinking about the most fundamental problems of the nation's public life, is an event that happened 87 years ago. 87 years actually before I was born. The event was the work of another man from Illinois, Senator Stephen A. Douglas. The event was 1854's enactment of the Kansas-Nebraska Act. It is not too much to say that a great question posed by that act continues to reverberate in the nation's life and certainly in my professional life. It reverberates in the nation's life not just because the Civil War is the hinge of American history, and the Kansas-Nebraska Act, which repealed the Missouri Compromise of 1820, was unquestionably the spark that lit the fuse that led to war. If the Civil War was not, in William Seward's famous phrase, an irrepressible conflict before 1854, it certainly was after that. The Missouri Compromise had been the work of Henry Clay, who Lincoln, in the first of his 7 1858 debates with Stephen Douglas, called my beau ideal of a statesman. The compromise somewhat diffused the slavery issue and sectional animosities for 3 decades. It did so by forbidding slavery in the Louisiana Territory north of a line that included the Kansas and Nebraska territories. The Kansas-Nebraska Act, introduced by Senator Douglas, empowered the residents of those 2 territories to decide whether or not to have the institution of slavery. The Act's premise was that the distilled essence of the American project is democracy, and that the distilled essence of democracy is majority rule, and that therefore it was right that there should be popular sovereignty in the territories regarding the great matter of slavery. People should have the right to vote it up or vote it down. Lincoln disagreed. He responded to the act with a controlled, canny, patient, but implacable vehemence. So, the most morally luminous career in the history of American democracy took its bearings from the principle that there is more to America's purpose, more to justice, than majorities having their way. Considering my origins in the land of Lincoln, there is a personally satisfying symmetry, which I did not recognize at the time, in the fact that 50 years ago I submitted to the politics department of Princeton University a doctoral dissertation titled Beyond the Reach of Majorities, Closed Questions in the Open Society. The title came from the Supreme Court's 1943 opinion in West Virginia v. Barnett, the second of the flag salute cases involving public school children who were Jehovah's Witnesses. As told by Professor Noah Feldman of New York University Law School in his splendid history, Scorpions, the Battles and Triumphs of FDR's Great Supreme Court Justices, the 2 cases, which culminated in one of the most striking reversals by the court in its history, began on an October morning in 1935 in Minersville, Pennsylvania, when William Gobitis, a 10-year-old 5th grader, refused to salute the flag during the Pledge of Allegiance. The teacher, Feldman writes, tried to force his arm up, but William held on to his pocket and successfully resisted. The next day, his sister Lillian, 11, a 5th grader, also refused to salute the flag, explaining to her teacher, quote, "The Bible says at Exodus chapter 20 that we can't have any gods other than Jehovah God." At that time, Feldman explains, the flag salute closely resembled the straight-arm Nazi salute, except that the palm was to be turned upward, not down. A national leader of the Jehovah's Witnesses had recently given a speech denouncing the Nazi salute, and several witnesses' children around the country had come to the conclusion that Lillian explained to her teacher, saluting the flag was idolatry. Lillian and William were shunned at school. The Gobitis family grocery store was threatened with violence and boycotted. The school district changed saluting the flag from a custom to a legal duty, and the Gobitis children were expelled from school. Well, their case wended its way to the Supreme Court as war clouds lowered over the world, a context, Feldman notes, that was not favorable to the witnesses. They were pacifists. They had opposed U.S. participation in the First World War and were opposing any U.S. involvement in any war in Europe. In June 1940, just days after Nazi troops marched into Paris, the court ruled 8-1 that the school district had the power to make saluting the flag mandatory. The opinion for the court was written by Justice Felix Frankfurter, a former member of the National Committee of the American Civil Liberties Union. He was Jewish and had been born in Austria, which the Nazis had occupied in 1938. As a Jew, he was anxious to avoid practices that allowed school children to be treated differently because of their religion. The case Millersville v. Gobitis dealt, he said, quote, with an interest inferior to none in the hierarchy of legal values. National unity is the basis of national security. Frankfurter said his personal opinion was that the school board should allow the witnesses' children their dissent. He was, however, as most political progressives had been for many decades, an advocate of judicial restraint regarding the actions of democratically elected bodies. And he thought the court should acknowledge that the elected school board had made a defensible, meaning reasonable, choice expressing the will of a majority of its constituents. The 8 members of the majority had all been appointed to the court by President Franklin Roosevelt, whose anger with the court's refusal to be deferential toward Congress's enactment of the New Deal legislation led to his ill-fated attempt to pack by enlarging the Supreme Court. The one dissenter in the Gobitis case was Harlan Fiske Stone, who had been appointed by President Calvin Coolidge, who I shall say parenthetically was the last president with whom I fully agreed. Minersville's flag salute law, wrote Stone, was unique in the history of Anglo-American legislation because it forced the children to express a sentiment which, as they interpret it, they do not entertain and which violates their deepest religious convictions. So, deference to the school board's legislative judgment amounted to, said Stone, the surrender of the constitutional protection of the liberty of small minorities to the popular will. As Feldman says, in 1940, the idea that the court should protect minorities from the majority was not the commonplace that it would later become. Stone had first introduced it in 1937, burying it in a footnote. Indeed, this became one of the most famous and consequential footnotes in the court's history. Taking their cue from the court, many communities across America made flag saluting mandatory. There was an upsurge of violence against witnesses, including that by a mob of 2,500 people who burnt down the witnesses' Kingdom Hall in Kennebunkport, Maine. In 1943, with the World War raging, the court agreed to hear another flag salute case concerning Jehovah's Witnesses for the purpose of overturning the decision it had reached just 36 months earlier with Gobitis. Writing for a majority in a 6-3 decision, Justice Robert Jackson, who had not been on the court when Gobitis was decided, said the following: "The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. Fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. First as a graduate student, then briefly as a professor of political philosophy, and now for more than 4 decades as a Washington observer of American politics and governance, I have been thinking about the many vexing issues implicated in these 2 flag salute cases. The issues include the source of American rights, the nature of the Constitution, and the role of the Supreme Court in construing it, and what fidelity to democracy requires regarding the rights of majorities. This is why I say that the Kansas-Nebraska Act reverberates in my professional life. It forced the nation and decades later me to confront a question that constantly takes new form but never goes away. It is the question of the limits of our commitment to majority rule. It is the question of how majoritarian we should be in our public life. This is a question of particular moment here at this distinguished law school because it concerns 2 questions that are, I hope and assume, at the center of legal education and scholarship here. The first is the nature and purpose of a written constitution. The second is the legitimacy of judicial review, and particularly whether judicial review really does involve what has been called a counter-majoritarian dilemma. There are those, and they might be an American majority, who believe that majority rule is the sovereign American value that trumps, if you'll pardon the expression, all others. They believe that the degree of America's goodness is defined by the extent to which majorities are able to have their way. Such people are bound to believe that it is the job of the judicial branch of government to facilitate this by adopting a modest, deferential stance regarding what legislatures do and regarding what executive branch officials and agencies do. Here, judicial deference is said to be dictated by the plebiscitary nature of the modern presidency. This began with the presidency of Andrew Jackson, but did not fully flower until modern communications technologies, especially radio and then television, changed the nature of the American regime by changing the nature of political campaigns and of governance. The current belief is that because presidents alone are elected by a national constituency, they are unique embodiments of the national will and hence should enjoy the maximum feasible, untrammeled latitude to translate that will into policies. The twofold problem is that majorities can be abusive, and some questions are not properly submitted to disposition by majority rule because there are some, actually there are many, closed questions even in an open society. So we must ask, how aberrant, how frequent are abusive majorities? A related but different question is, when legislatures, which are majoritarian bodies, act, how often are they actually acting on behalf of majorities? My belief, based on almost a half-century observing Washington, the beating heart of American governance, is this. As government becomes bigger and more hyperactive, as the regulatory administrative state becomes more promiscuously intrusive in the dynamics of society and the lives of individuals, only a steadily shrinking portion of what the government does is even remotely responsive to the will of a majority. Rather, the more government decides that there are no legal or practical limits to its practical scope, and actual competence, the more time and energy it devotes to serving the interests of minority, often very small minority factions. So, paradoxically, as government becomes bigger, its actions become smaller. As it becomes more grandiose in its pretensions, its preoccupations become more minute. Let me offer a few examples from governments below the federal level. Ali Bukhari emigrated to America from Pakistan in the year 2000, settled in Nashville and became a taxi driver, and then got a very American idea. He started a business to serve an unmet need. He bought a black Lincoln Town car and began offering cut-rates rides to and from the airport, around downtown, and in neighborhoods not well served by Nashville taxis. After 1 year, he had 12 cars. Soon he had 20, and 15 independent contractors with their own cars, and a website, and lots of customers. Unfortunately, he also had thereby earned some powerful enemies. The cartel of taxi companies had not been able to raise their rates since Bukhari came to town. Those companies, in collaboration with older limo companies that resented Bukhari's competition, got the city government's regulators to require him to raise his prices and to impose many crippling regulations. Another example. Sandy Meadows was an African-American widow in Baton Rouge. She had little education and no resources, other than her talent for making lovely flower arrangements, which a local grocery store hired her to do. Then Louisiana's Horticulture Commission, yes, there really is one, pounced. It threatened to close the store in order to punish it for hiring an unlicensed flower arranger. Meadows tried but failed to get a license, which required her to take a written test, to make 4 arrangements in 4 hours. The adequacy of the arrangements was judged by licensed florists who were acting as gatekeepers to their own profession, restricting the entry into their profession of competitors. Meadows, denied re-entry into the profession from which the government had expelled her, died in poverty. But the people of Louisiana were protected by their government from the menace of unlicensed flower arrangers. Elsewhere in Louisiana, the monks of St. Joseph Abbey also attracted government's disapproving squint. In 2005, Hurricane Katrina damaged the trees that for many years the monks had harvested to finance their religious life. Seeking a new source of revenue, they decided to make and market the kind of simple wooden caskets in which the abbey has long buried its dead. The monks were unwittingly about to embark on a career in crime. Louisiana has a state board of embalmers and funeral directors. Its supposed purpose, when created in 1914, was to combat infectious diseases. It has, however, long since succumbed to what is called regulatory capture. That is, it has been taken over by the funeral industry it ostensibly regulates. At the time the monks began making and selling caskets, 9 of the board's 10 members were funeral directors, one of whose principal sources of income is selling caskets. In the 1960s, Louisiana had made it a crime to sell funeral merchandise without a funeral director's license. To get a funeral director's license, the monks would have had to stop being monks. They would have had to earn 30 hours of college credits and to apprentice 1 year at a licensed funeral home to acquire skills they had no intention of ever using. And their abbey would have been required to become a funeral establishment with a parlor able to accommodate 30 mourners and they would have had to install an embalming facility, even though they only wanted to make rectangular wooden boxes and not handle cadavers. Now, the law requiring all this rigmarole served no health or sanitary purpose. Louisiana does not stipulate casket standards or even require that burials be done in caskets. Furthermore, Louisianans can buy caskets from out of state, from, for example, Amazon, which sells everything. Obviously, the law that was brought to bear against the monks was an instrument of unadulterated rent-seeking by the funeral directors to protect their casket-selling cartel. Rent-seeking occurs when private interests bend government power to their advantage in order to confer favors on themselves, often by imposing impediments on actual or potential competitors. Now, you may well be thinking that I have wandered far from the Kansas-Nebraska Act, and you may be wondering what all this has to do with Abraham Lincoln and with the work of a political commentator. Here is my answer. The government action that was used to prevent a Pakistani immigrant from entering into his chosen profession of operating a transportation company, and the government action that blocked an aspiring flower arranger from exercising her skill and consigned her to die in poverty, and the government action that blocked the monks from supporting themselves by making and selling wooden boxes. All these actions, and thousands like them from coast to coast, should be, but usually are not, considered unconstitutional. They should be struck down, even though they have issued from majoritarian processes, from elected officials and from regulatory agencies created by elected officials. They should be struck down as violations of a natural right, the right that Lincoln understood as the right to free labor, the right that was, of course, at the core of the slavery crisis. It is the unenumerated but surely implied constitutional right to economic liberty. But laws abridging that right survive and proliferate today because courts have long since the New Deal, stopped doing their duty to defend this economic liberty against the rent-seeking enemies. In a sense, the problem began in Louisiana 16 years before the monks' monastery was founded in 1889. It began across Lake Pontchartrain from the monastery in New Orleans. That city had rewarded some rent-seeking butchers a lucrative benefit. The city had created a cartel for them by requiring that all slaughtering be done in their slaughterhouses. Some excluded butchers went to court, all the way to the U.S. Supreme Court, challenging this law. They lost when, in the 1873 slaughterhouse cases, the court, in a 5-4 decision, upheld the law that created the cartel. In doing so, the court effectively expunged a clause from the 14th Amendment. The clause, written to nationalize the rights of American citizenship, says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." The court construed the phrase privileges or immunities very narrowly, so narrowly that it disappeared from constitutional law. A melancholy fate for a phrase that was, as I say, intended as a shorthand for the full panoply of rights of national citizenship, particularly for the benefit of the newly freed slaves. Intermittently since then, and steadily since the New Deal, courts have abandoned the protection of economic rights, including the fundamental right to earn a living without arbitrary and irrational government hindrances. Instead, courts have adopted the extremely permissive rational basis test for judging whether government actions are permissible. Courts almost invariably hold that if a government stipulates a reason, any reason, for a law that or regulation that burdens economic activity, or if the court itself can even imagine on the legislature's behalf a reason for the law, even if the law or regulation reeks of rent-seeking, then the court should defer to the elected legislature, elected city council, or other majoritarian institution that is the ultimate source of the law or regulation. Indeed, in 2004, the 10th Circuit Court upheld a notably ludicrous Oklahoma law requiring online casket retailers to have funeral licenses. To obtain such licenses, applicants are required to take several years of coursework, to serve a one-year apprenticeship, to embalm 25 bodies, and take 2 exams for online sellers. Upholding this travesty of an Oklahoma law, the court wrote with breezy complacency that, and I quote, "While baseball may be the national pastime of the citizenry, dishing out special economic benefits to certain in-state industries remains the favored pastime of state and local governments." The court did not say, but it might as well have said, majority rule requires that courts only reluctantly and rarely engage in the judicial supervision of democracy, because majority rule is the essence of the American project. There are, however, 2 things wrong with this formulation. First, it is utterly unrealistic and simple-minded to think that there is a majority support for, or majority interest in, or even majority awareness of, even a tiny fraction of what modern governments do in dishing out advantages to economic factions. Does anyone really think that when the Nashville city government dispenses favors for the taxi and limo cartels, it is acting on the will of the majority of the city's residents? Can anyone actually believe that a majority of Louisianans give a tinker's damn about who sells caskets or arranges flowers? The second and more fundamental fallacy behind a passive judiciary deferring to majoritarian institutions is this: we know, because he said so clearly and often, that Lincoln took his political bearings from the Declaration of Independence. We know that Lincoln believed, because the Declaration says this is so, that governments are instituted to secure our rights. These rights, therefore, pre-exist governments, which do not create our rights. And they include the unenumerated ones affirmed in the Constitution's 9th Amendment, which reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Which brings me, by an admittedly circuitous route, back again to 1854, to the Kansas-Nebraska Act, and to Lincoln's noble recoil from the idea of popular sovereignty in the territories regarding slavery. That recoil propelled Lincoln from semi-retirement from politics and into a debate that still reverberates. Lincoln's recoil against the idea of untrammeled majorities produced the most luminous public life in our nation's history, and I believe in world history. For many years, and for several reasons, many of my fellow conservatives have unreflectively and imprudently celebrated judicial restraint. For many years, I too was guilty of this. The reasons for this include an understandable disapproval of some of the more freewheeling constitutional improvisations of the Warren Court, and the reasonable belief that the law schools that train future judges and the law reviews that influence current judges are, on balance, not balanced, that they give short shrift to conservatism. It is, however, high time for conservatives to rethink what they should believe about the role of courts in the American regime. Another reason many conservatives favor judicial deference and restraint is what can be called the conservative populist temptation. Conservatives are hardly immune to the temptation to pander, to preach that majorities are presumptively virtuous, and that the things legislatures do are necessarily right because they reflect the will of the virtuous majority. However, the essential drama of democracy derives from the inherent tension between the natural rights of the individual and the constructed right of the community to make such laws as the majority deems necessary and proper. Natural rights are affirmed by the Declaration of Independence. Majority rule, circumscribed and modulated, is constructed by the Constitution. Timothy Sandifer of the Goldwater Institute in Phoenix, in his book, The Conscience of the Constitution, rightly emphasizes that the Declaration is not just chronologically prior to the Constitution, it is logically prior. Because it sets the framework for reading the Constitution, it is the Constitution's conscience. By the terms with which the Declaration articulates the Constitution's purpose, the purpose is to secure unalienable and natural rights. The Declaration intimates the standards by which to distinguish the proper from the improper exercises of majority rule. Freedom, writes Sandifer, is the starting point of politics. Government's powers are secondary and derivative, and therefore limited. Liberty is the goal at which democracy aims, not the other way around. The progressive project, now entering its second century, has been to reverse this by giving majority rule priority over liberty when the two conflict, as they inevitably and frequently do. This reflects the progressive belief that rights are the result of government, that they are spaces of privacy that government has chosen to carve out and protect. If the soul or overriding goal of the Constitution can be reduced to establishing democracy, and if the distilled essence of democracy is that majorities shall rule in whatever sphere of life where majorities wish to rule, then the court is indeed a deviant institution. But such a reductionist understanding of American constitutionalism is passing strange. It is excessive to say, as often has been said, that the Constitution is undemocratic or anti-democratic or anti-majoritarian. It is not, however, too much to say that the Constitution regards majority rule as but one component in a system of liberty. The principle of judicial restraint, distilled to its essence, frequently is the principle that an act of the government should be presumed constitutional, and that the party disputing the act's constitution bears the heavy burden of demonstrating the act's unconstitutionality beyond a reasonable doubt. The contrary principle that I will call judicial engagement is that the judiciary's principal duty is the defense of liberty, and that the government, when challenged, bears the burden of demonstrating that its action is in conformity with the Constitution's architecture, the purpose of which is to protect liberty. The federal government can dispatch this burden by demonstrating that its action is both necessary and proper for the exercise of an enumerated power. A state or local government can dispatch the burden by demonstrating that its act is within the constitutionally prescribed limits of its police power. Judge Don Willett of the Texas Supreme Court has cogently addressed and largely dissolved the supposed counter-majoritarian difficulty. There are, he says, two different but not equal majorities involved. He begins as judicial review began in 1803 with Marbury v. Madison, in which Justice Marshall wrote, "The powers of the legislature are defined and limited, and that those limited limits may not be mistaken or forgotten, the Constitution is written. In distinguishing between proper judicial deference to legislative majorities and the dereliction of the judicial duty to police majoritarian excesses," Willett says, "in our democracy, the legislature's policy-making power, though unrivaled, is not unlimited. The Constitution is supreme, and desirable is not a synonym for constitutional. Although the political branches decide if laws pass, it is for courts to decide if laws pass muster. So, if judicial review means anything, it is that judicial restraint does not allow everything. To avoid a constitutional tipping point where adjudication more resembles abdication, courts must not extinguish constitutional liberties with nonchalance. This requires fidelity to the supermajority against which other majorities must be measured, the supermajority of those who wrote and ratified the Constitution. There must, Justice Willett writes in a Texas case, remain judicially enforceable constraints on legislative actions that are irreconcilable with constitutional commands. Why must? Because, says Willett, the Texas Constitution, like the U.S. Constitution, is irrefutably framed in prescription. It declares an emphatic no to myriad government undertakings, even if majorities desire them. Judicial review means preventing any contemporary majority from overturning yesterday's supermajority, that one that wrote and ratified the Constitution. Federal judges are accountable to no current constituency. But when construing the Constitution, today's judges are duty-bound to be faithful to the constituency of those who framed and ratified it. This, says Willett, is the profound difference between an improperly activist judge and a properly engaged judge. The former creates rights that are neither specified in nor implied by the Constitution. The latter defends rights the framers actually placed there and prevents the elected branches from usurping the judiciary's duty to declare what the Constitution means and implies. It is not true that, as Dr. Stockman declares in Heinrich Ibsen's play The Enemy of the People, the majority is always wrong. It is true that the majority often is wrong, and that the majority, even when wrong, often has a right to work its will anyway. Often, but not always. The challenge is to determine the borders of the majority's right to have its way, and to have those borders policed by a non-majoritarian institution, the judiciary. So, to Dean Amar's question about how Lincoln has influenced my life, my answer is this. By his noble rejection of the Kansas-Nebraska Act and the idea of popular sovereignty as the way to decide the question of slavery in the territories, Lincoln concentrated my mind on two timeless truths. One is that majority rule is inevitable, but not inevitably reasonable. The other is that moral reasoning, properly done, and the Constitution, properly construed, both affirm that many things should be beyond the reach of majorities. Thank you very much.